We are covering Chapter 18, Trial Before a Court of Session of CrPC 1973. Trial Before a Court of Session is under Section 225 to 237. This is Part 5 and now we are going to cover Section 232 to 237. We have already covered Section 225 to 231 in our previous video lecture. If you want to check, the link is given below. Now we come to Section 232, which is about acquittal. Section 232, acquittal. If after taking the evidence for the prosecution, examining the accused, and hearing the prosecution and the defense on the point, the judge considers that there is no evidence that the accused committed the offense, the judge shall record an order of acquittal. So what does it mean? It means, number 1, evidence for the prosecution is taken. 2, examining of the accused is done. 3, hearing is done for both the prosecution and the defense. 4, the judge considers that there is no evidence that the accused committed the offense. And the 5th point, the most important, the judge can pass order of acquittal, but he has to give the reasons, with reasons. I'm showing you one clip. This is going to clarify everything. Watch this carefully. This is for educational purpose only. The intention is not to hurt anyone. If we consider this as a court and imagine Bhumi Irani, the actor over here, appearing as an advocate from defense side. So he is playing the role of a defense counsel, defending his client that he has not committed the crime of hit and run death case. On other hand, the prosecution does not have any evidence that he was involved in hit and run case. So Bhumi Irani, that is the defense counsel, informs the judge, since there is no evidence from the prosecution side, they cannot prove the crime. And in this scene, the verdict of the judge was not guilty, which constitute an acquittal under Section 232 of CrPC 1973. Now we come to Section 233, entering upon defense. Section 233 has 3 subsections. Subsection 1 says, where the accused is not acquitted under Section 232, he shall be called upon to enter on his defense and adduce any evidence he may have in support thereof. And subsection 2 of 33 informs us, if the accused puts in any written statement, the judge shall file it with the record. And subsection 3 informs us, if the accused applies for the issue of any process for compelling the attendance of any witness, production of any document or a thing, the judge shall issue such process unless he considers for reasons to be recorded that such application should be refused on the ground that it is made for the purpose of vexation or delay or for defeating the ends of justice. Subsection 1 of Section 233 informs us that in case accused under Section 232, which we just covered, is not acquitted, then in such a situation, the accused will be asked to bring evidence to support his innocence. Subsection 2 of 233 informs us that if a written statement is given by the accused, it will be filed by the judge for record purpose. And subsection 3 of 233 informs us, in case the accused has applied to the court to support his innocence, the attendance of any witness or production of a document or a thing. In such a case, the judge has 2 options. 1, he shall order to be brought it to the court on next hearing, and second, the judge can refuse that such attendance of a witness or production of a thing or a document is not required. This may be because the accused just want to delay the case. This is what Section 233 informs us. On filing of public interest litigation, the case was reopened. The accused was not acquitted and was asked to bring his defense under Section 233 subsection 1. And you can see here Bhumi Irani, playing the role of defense counsel, brings driver of the car as witness evidence. Everyone who saw this movie knows about it, but that's ordinary thing. But from advocate or student of LL.B. LLM point of view, one must know that this is done under subsection 1 of section 233 of Criminal Procedure Code 1973. Now we come to section 234, arguments. Only from experience of the code, the students can get the skills of arguments. So when a student is going through the internship, never miss the argument part of the case. Section 234, when the examination of the witnesses, if any, for the defense is complete. So we got the point that examination of the witnesses, if it was taken up, is completed. Now what's gonna happen? The prosecutor shall sum up his case and the accused or his pleader shall be entitled to reply. So finally the case has been completed from the prosecutor side, and if the accused or his pleader wants to give any clarification or reply, he shall be asked to do so. But there is a condition to it, provided that, which means subject to condition. Where any point of law is raised by the accused or his pleader, the prosecution may, with the permission of the judge, make submissions with regard to such point of law. So finally the case is coming to an end, and if there is question regard to the point of law, only in such case the prosecution will be replying on it. Otherwise the case has come to an end. After section 234 the arguments is completed, we come to section 235, which is judgment of acquittal or conviction. Now we come to section 235, which is judgment of acquittal or conviction. Subsection 1 says, after hearing the arguments and the point of law, if any. Now the argument is over. If there is a question on the point of law, it's also covered. The judge shall give judgment in the case. So law students, please do not forget, it is subsection 1 of 235 which speaks about a judge giving the judgment in the case. Do not speak just section 235. Please mention subsection 1 of 235. Next, subsection 2 of 235 says, if the accused is convicted. Now what is gonna happen when the judgment has been pronounced by the judge and he is convicted the accused? The judge shall, unless he proceeds in according to the provision of section 360. Now write in the comments what is section 360 about. So if the accused is convicted, the judge shall hear the accused on the question of sentence and then pass sentence on him according to law. So when the judgment is done to acquit or convict, we come to section 236, which speaks about previous conviction. If there is a previous conviction, then what's gonna happen? Let's check that out. Section 236 is previous conviction. It says that in a case where previous conviction is charged under section 211 of, as per subsection 7, the accused does not admit that he had been previously convicted as alleged in the charge. Now there is a situation. We may say that he has been previously convicted, but the accused says, no, I have not been convicted. So in such a situation, what's going to happen? The section further informs us, the judge may, after he has convicted the said accused under section 229 or section 235, the evidence in respect of the alleged previous conviction, and shall record finding thereon. So judge is going to take the action subject to condition, provided that. Now the section has a condition which says, no such charge shall be read out by the judge, nor shall the accused be asked to plead thereto, nor shall the previous conviction be referred by the prosecution or in any evidence adduced by it, unless and until the accused has been convicted under section 229 or 235. Why are we saying this? It is very obvious. If the accused has not been convicted, if he is acquitted, there is no reason that we will go further to explain that he has been convicted in previous conviction. So this provision is relevant only in case where the accused is convicted. If it is acquitted, then section 236 will not come into force. Now we come to the last section of this chapter, section 237. It speaks about procedure in cases instituted under section 119 subsection 2. It has got 8 subsections. Let's check them out. Section 237 informs the procedure when a case is prosecution for defamation. Defamation of Vice President, President, Governor, Administrator, Minister of the Union or the state, or public servant in capacity of his duties. In such cases, section 237 comes in force and subsection 1 says a code of session taking cognizance of an offence under subsection 2 of section 199 shall try the case in accordance with the procedure for trial of warrant cases instituted otherwise than a police report before a court of magistrate. So subsection 1 is informing that the procedure what is going to be adopted is the same as it is adopted in a warrant cases on the basis of a complaint other than a police report. And there is a condition to it, provided that the person against whom the offence is alleged to have been committed shall, unless the code of session for reasons to be recorded otherwise directs, be examined as witness for the prosecution. And subsection 2 of section 237 informs that every trial under this section shall be held in camera, if either party thereto so desires or if the court thinks so to do. Means either on the wishes of the party or the court on itself can order the recordings, the trial to be done under camera. Now subsection 3 talks about the acquittal of the case. It says if in any such case the court discharges or acquits all or any of the accused and is of opinion that there is no reasonable cause for making the accusation against them or any of them, which means either the single person or all of the persons. It further says it may by its order of discharge or acquittal direct the person whom the offence was alleged to have been committed other than the president, vice president, governor or the administrator of the union to show cause why he should not pay compensation to such person or accused, to such accused or to each or any of such accused when there are more than one. So the compensation might be given to one or all of the accused in case they are acquitted. Subsection 4 says the court shall record and consider any cause which may be shown by the person so directed, and if it is satisfied that there is no reasonable cause for making the accusation, it may for reasons to be recorded make an order that compensation to such amount not exceeding 1,000 as may be determined be paid by such person to the accused or to each or any of them. See, this is for accused person. The court is doing it for the accused person, that he should be compensated. If the prosecution is not able to satisfy the court that why they should not compensate the accused, then the court on its own will fix an amount which should not be more than 1,000 to be paid to accused person. However, this is not going to be said to president, vice president, governor, administrator, minister of the union or the states or the government servant. Now subsection 5 of 237 says the compensation which is awarded under subsection 4 shall be recovered as if it were a fine imposed by a magistrate. Obviously, the magistrate has fixed the amount. And subsection 6 says no person who has been directed to pay compensation under subsection 4 shall be, by reason of such order, be exempted from any civil or criminal liability in respect of the complaint made under this section. So this is important one. This does not play as res judicata. One cannot say that I have already paid a 1,000 or whatever the court has fixed for compensation as defamation if a person goes for a civil or a criminal suit on the same matter. Subject to condition. There is a condition to this also. It says that provided that any amount paid to an accused person under this section shall be taken into account in awarding compensation to such person in any subsequent civil suit relating to the same matter. See, a criminal or a civil case, if instituted on the same matter, will not be affected. But when the matter is regarding the compensation paid in this case will be taken into account. That shall not be ignored. Now we come to subsection 7 of 237. It says the person who has been ordered under subsection 4 to pay the compensation may appeal from this order insofar as it relates to the payment of compensation to the High Court. Yes, it is very obvious. One can appeal. This means these are appealable orders. And now we come to the last one, subsection 8 of 237. It says when an order for payment of compensation to an accused person is made, the compensation shall not be paid to him before the period allowed for the presentation of the appeal has elapsed, or if an appeal is presented before the appeal has been decided. This is very obvious that if a person has already appealed, so there is no reason for the party to make payment. They will make payment only after the outcome of the appeal as well. If you check properly, subsection 4 is regarding the compensation and rest of the sections from 5 to 8 speaks about subsection 4 only. With this we come to end of this chapter 18, and before we come back, do remember to respect your elders and love kids, otherwise all the education is wasted.